Good morning. This is your Kelso Report for Friday, March 9th. I'm your host, Clark Kelso. We've got quite a few cases today dealing with habeas corpus, debt collection, criminal law, negligent hiring and supervision, an anti-SLAPP case, medical malpractice, and remedies. Let's jump right in with the Ninth Circuit and a habeas case, a second and successive habeas case. Now, as a general matter, as you know, an inmate only gets one shot at a federal habeas petition. Once that petition has been denied, the bar to a second or successive petition gets raised considerably higher. In order to get judicial approval to file a second or successive petition, there either has to be a new rule of constitutional law which the Supreme Court itself has made retroactively applicable to collateral proceedings, or there has to be newly discovered evidence that could not have been previously discovered, and that evidence must establish by clearly and convincingly that but for the constitutional error, no reasonable fact finder would have found the applicant guilty of the underlying offense. Essentially, the court has to conclude that the petitioner was actually innocent. Well, in Pizzuto v. Blades, the petitioner presented new evidence of prosecutorial misconduct, judicial misconduct, a claim of cumulative error, and a claim of actual innocence. Part of the evidence here was that the judge and prosecutor, in the context of an earlier proceeding, had negotiated a plea bargain with a different defendant in return for key testimony against the petitioner in this trial. Well, but none of the new evidence, even the troubling evidence of alleged collusion between the judge and prosecutor, came anywhere close to proving actual innocence. At best, the allegations, if true, raised serious concerns about the fairness of the trial and about the reliability of some of the evidence. But as the majority noted, there was still plenty of other physical evidence connecting the petitioner to the crime, and given the high standard for granting a request to file a second or successive habeas petition, that evidence was sufficient to support the conviction. Judge Fletcher's dissent essentially disagrees with the standards set by Congress in the Anti-Terrorism and Effective Death Penalty Act for second or successive petitions. As she said at the close of her dissent, quote, "We should rejoice in a system that allows a second habeas challenge when diligent counsel is able to uncover the facts and present them to us before a man is put to death," close quote. Well, maybe we should rejoice, but Congress has decided to end the party after the first habeas petition, except in very rare circumstances. Next, we have a consumer protection case involving federal debt collection law. The Federal Fair Debt Collection Practices Act bars the use of any false, deceptive, or misleading representation in connection with the collection of any debt. The FDCPA is a strict liability statute. There is no mental state required to violate it. In Cruz v. International Collection Corporation, the debt collector, ICC, sent letters to the plaintiff, Cruz, claiming that Cruz was liable for prejudgment interest, fees, and treble damages if he didn't pay up. Well, the parties agreed at oral argument that Nevada law governs this debt, although that had previously been in dispute. Under Nevada law, a debt collector may not collect any interest or fees unless the interest or fees have been added to the principal by the creditor before the debt collector received the item of collection. There was no evidence that interest or fees had been previously added to the principal, so the district court granted summary judgment in favor of the plaintiff because of the defendant's false, deceptive, and misleading letter. The Ninth Circuit affirmed. The best the defendant could offer on appeal was that they made a bona fide good faith error in believing that California law applied. The Ninth Circuit rejected this argument, first because the defense had not been raised before the district court, so the Ninth Circuit considered the issue to have been waived, and second, because some of the statements in the letter were false, even under California law. Next, we turn to the Supreme Court of California that had an interesting criminal law case. According to Section 246 of the Penal Code, it is unlawful for, quote, any person to maliciously and willfully discharge a firearm at an inhabited dwelling house, occupied building, occupied motor vehicle, occupied aircraft, inhabited housecar, or inhabited camper, close quote. The defendant was standing outside a vehicle, but had thrust the gun into the vehicle at the time he fired the weapon, which killed someone in the vehicle. The question was whether the statute applied to this factual situation. The people argued that because the defendant was standing outside the vehicle, he was discharging the firearm at the vehicle. The defendant argued that the word "at" must be interpreted from the location of the firearm, such that the firearm, which has already crossed the plane of the vehicle, is no longer shooting at the vehicle, but is instead shooting within the vehicle. The Court of Appeal had sided with the defendant, citing the ambiguity of the statute and the rule of lenity, which favors defendants in criminal cases. But the Supreme Court of California reversed unanimously, based upon its conclusion that the evident focus of the statute was the special dangers associated with shooting into a home or vehicle, and that those dangers do not magically disappear when a portion of a firearm passes through a door or window. As for the rule of lenity, the court noted that it applies only when alternative interpretations are equally plausible and convincing. But here, the alternative interpretation put forward by the defendant, while not entirely irrational, is much weaker than the interpretation adopted by the court. The Supreme Court also had a negligent hiring and supervision case in a school district. The case is CA versus William S. Hart Union High School District, where the court held that Section 815.2 of the Government Code does indeed authorize a suit for negligent hiring and supervision in a school district context. Factually, the case involved a high school counselor who harassed and abused a student. The student sued, and the Superior Court and Court of Appeal held that the school district could not be held vicariously liable for the counselor's misconduct, which was outside the scope of her employment, and also could not be held liable under a negligent hiring or supervision claim. The Supreme Court unanimously reversed, permitting the plaintiff to move forward with his claim that the district can be held vicariously liable for the negligence of supervisory or administrative personnel who allegedly knew or should have known of the counselor's propensities and nevertheless hired, retained, and inadequately supervised her. The court reasoned that because school personnel owe students under their supervision a protective duty of care, if a supervisory or administrative employee of the district is proven to have breached that duty by negligently exposing plaintiff to a foreseeable danger of molestation by his guidance counselor, liability may be imposed. Now, the court emphasized in its holding the special relationship that school administrators and supervisors have to care for the students in their charge. And, absent that special relationship, the court indicated there can be no individual liability to third parties for negligent hiring, retention, or supervision of a fellow employee, and hence no vicarious liability under Section 815.2. In reaching this holding, the Supreme Court obviously was concerned that it might have just opened up every single student sex abuse case into a suit against the school district for negligent hiring and supervision. And the court cautioned that, quote, a district's liability must be based on evidence of negligent hiring, supervision, or retention, not on assumptions or speculation. That an individual school employee has committed sexual misconduct with a student or students does not of itself establish or raise any presumption that the employing district should bear liability for the resulting injuries, close quote. Well, all I can say about that is we'll have to wait and see if those cautions don't get overwhelmed in very short order by sympathetic plaintiffs with bad facts. At a minimum, lawyers representing school districts now need to re-examine how administrators and supervisors should be conducting themselves in hiring and supervising school staff. Furthermore, whether the limitations in the court's opinion to this special relationship category, whether that's going to hold with respect to other governmental agencies, will be interesting to see. Next, we have an anti-SLAPP case. The plaintiff in this was a veterinarian who, back in 2002, had been accused by his wife's former husband of prescribing a drug for human use. With lightning speed, the Veterinary Medical Board undertook a 2-year investigation and ultimately imposed a very small fine and brief suspension of his license. Well, he then successfully challenged the board's decision in an administrative writ of mandate. And he turned around and sued pretty much everybody involved, and the board responded with an anti-SLAPP motion. Everyone agreed that the anti-SLAPP statute applied, and so the only question was whether the plaintiff probably would prevail. At this point, the plaintiff tried to take a shortcut by asking the Superior Court to take judicial notice of the minute order overturning the fine and suspension. Unfortunately for the plaintiff, the courts distinguish between taking judicial notice of the fact that a minute order has been entered and the question of whether the facts and conclusions in the minute order are true. Judicial notice covers issuance of the order, but it does not require the Superior Court to assume that all of the facts and findings are true. Since this was the only evidence the plaintiff introduced in response to the anti-SLAPP motion, the Second District held in Steed v. Department of Consumer Affairs that the plaintiff failed to prove he probably would prevail on the merits. So the court affirmed the Superior Court's decision to strike the complaint under the anti-SLAPP statute. Next, we have a remedies case. There it is, I've got it out of order. The plaintiff, a home health care worker employed by a private company, was injured by an elderly woman she was taking care of. The plaintiff sued the estate of the patient after the patient had died, and the estate asserted comparative fault by the plaintiff and the plaintiff's employer as an affirmative defense. The jury found that the elderly patient was 50% at fault, and that the plaintiff's employer was 50% at fault, with total damages of $900,000. The plaintiff appealed the finding of fault against her employer on sufficiency of evidence grounds, but the Second District held in Sanchez v. Brook that the evidence was sufficient to support the jury's fault determination. Of much greater interest, though, the court extended to the context of a workers' compensation payment the rule recently adopted by the California Supreme Court in Howell v. Hamilton Meats and Provisions that an injured person's recovery of past medical expenses as economic damages was limited to the discounted amount that the medical providers accepted as payment in full from the injured person's private health insurance carrier. Now, in Sanchez, the injured employee's medical provider accepted a discounted amount as payment in full from the employer under the workers' compensation law. Applying Howell in this context, the court in Sanchez concluded that because the injured employee is not liable for the undiscounted sum stated in the provider's bill, the unpaid balance does not represent an economic loss to the plaintiff and is not recoverable as damages. As a result, the court remanded for damages to be reduced by an appropriate amount. Now we'll go back to my torts and medical malpractice case. The plaintiff here was a minor who was injured during a tonsillectomy when the equipment being used to perform the operation, allegedly because of malpractice by the surgeon and or a defect in the equipment itself, amazingly caused a fire briefly to erupt in the plaintiff's mouth, resulting in serious burns and smoke inhalation. The fire actually was started because one of the instruments in the mouth had oxygen coming into it and the other got hot. Well, the complaint alleged that the patient suffered brain damage as a result of oxygen deprivation. Although the defense evidence suggested the deprivation in oxygen would have been extremely brief, and that the patient had reduced mental capacity even before the operation. The plaintiff sued the doctor for malpractice and the equipment manufacturer for product liability. Defense counsel for the manufacturer made a number of improper closing arguments, including that the suit was nothing more than an attempt to recover against a deep-pocket defendant, that the jury needed to send a message to the family, and that a judgment is going to end up costing the jurors money. Plaintiff made a motion for new trial after defense counsel closed, and the trial court found that the argument was indeed improper, an improper appeal to the passion and prejudice of the jury. However, the trial court denied the request for a new trial, and instead admonished the jury to ignore the deep pocket statement, the statement that the jurors themselves had a stake in the verdict, and that the jury should send a message with its verdict. The jury returned a $750,000 judgment against the doctor for malpractice, but it returned a defense verdict in favor of the manufacturer. The plaintiff had requested $30 million in damages and had argued that most of the fault lay with the manufacturer. So the plaintiff appealed the defense verdict and the refusal to grant a new trial. In Garcia v. ConMed, the 6th District affirmed the judgment, concluding that while the jury argument was indeed improper, it was of brief duration and had been adequately cured by the trial court's specific admonishment. And the evidence of design defect was not strong and had been controverted by testimony for the defense. As a result, the misconduct in closing argument was harmless, since it was not reasonably probable that the plaintiff would have obtained a more favorable judgment in the absence of the argument. And that's it for today's Kelso Report. Have a great day in the law and a good weekend. See you next week.